Everybody, I'm Colonel Ravinder Singh, the Secretary General of BCIC. I extend a very warm welcome to you all for this very informative session that we'll have on GCC, the impact of the new labor codes on GCC. We have a very eminent panel here who will be talking about it. We have Mr. Prashanth Doreswamy, who's the chairperson of the GCC committee, and he also heads Continental. So I'll just give you a brief on each of the speakers. Mr. Prashanth Doreswamy is a seasoned business leader with extensive experience in driving growth, innovation, and digital transformation across GCCs and technology-driven organizations. He has played strengthening India's position as a hub for global GCCs, fostering collaboration, talent development, and industry-academia partnerships. He is actively engaged in industry forums, contributing strategic insights on emerging technologies, leadership, and the evolving role of GCCs. We also have Mr. Ankur Agrawal. We extend a very warm welcome to you.
Thank you.
He's a HR leader with strong expertise in global people solutions, driving talent strategy, workforce transformation, and organizational effectiveness across different industries. He has significant experience in advising organizations on HR consulting, including performance management, compensation structuring, and enhanced employee experience in dynamic business environments. He actively transformation, enabling organizations to align human capital with business development. Vijai Jayaram from Thornton. A very warm welcome to him also. He's a chartered accountant with over 20 years of experience in tax and regulatory services, with a strong focus on GCC ecosystem and evolving business landscapes. He advises clients across sectors such as technology, fintech, e-commerce, and manufacturing, with expertise in corporate and international tax, structuring, FDI, and tax litigation. He actively contributes to thought leadership on emerging tax trends through leading business publications, offering insights that shape industry perspectives. I now hand you over to Mr. Prashanth Doreswamy to set the... Over to you, sir.
Thank you, Colonel. Good afternoon, everyone. First of all, my apologies for not being there in person due to some customer urgencies. I had to travel to Delhi. Warm welcome and thank you for joining us today's webinar on the impact of new labor codes on global capability centers, especially. As many of you are aware, India's new labor codes represent one of the most, I would say, the significant overhauls in the regulatory framework, which has been pending for the last several years, which governs employment in decades, I would say. By consolidating multiple legal laws they try to combine under four pillars or comprehensive codes. These reforms is basically aimed to simplify compliance, enhance transparency, and also improve ease of doing business. At the same time, they introduce important changes in areas such as wages, social security, industrial relations, and also the occupational safety. For global capability centers, which play a critical role in driving innovation, operational excellence, and also the global integration, these changes bring both, I would say, opportunities as well as challenges. Organizations will need to carefully assess the implications on the workforce restructuring, cost models, compliance requirements, and also employee engagement practices, I would say. So in today's session, we will explore the key provisions of the new labor codes relevant to GCCs, potential operational and financial impacts, each of them could have this, and compliance considerations and timelines, and also practical strategies to navigate the transition effectively. To deep dive into this critical topic, we have with us Mr. Ankur Agrawal, Director, Global People Solutions, Grant Thornton Bharat LLP. And also this session will be moderated by Mr. Vijai Jayaram, partner, Walker Chandiok Company. Our goal is to provide you with a very clear insights and also sort of an actionable perspectives to help your organizations how you can stay ahead of these regulatory changes. We hope you find this session very insightful and engaging. Thank you once again for being here. And with that, I would hand it over to Mr. Vijai Jayaram.
Thanks, Prashanth. Too bad you couldn't be here, but thanks for explaining and setting the context on this call. Thank you everyone for joining this webinar. I think the way we are planning to do this is that Ankur has a slide deck where he's going to deep dive into some of these labor code provisions and areas. But before that, and during the course of this presentation, we also invite questions. So you're not restricted to asking questions only at the end. Please feel free to ask questions on any topic as and when we go through the webinar. And with that, I'll just do some context setting with Ankur and we'll start things off. Ankur, now our labor regulations date back more than 100 years. So it's been a long time in the making. And now it's been 4-5 years of draft rules as well. What is our current status? Is it completely effective? There's a lot of hubbub that we hear on it's partially effective. There are state-specific rules that are to come out. So what is the real situation? And has the situation changed further after we come into the new year now? We are on April 2nd now. Right. So that's perhaps, I think, the burning topic on everyone's mind before we deep dive.
Right. Thanks, Vijay, and thanks, Prashanth. Thanks, everyone. A very relevant question Vijay has raised. A lot of clients are asking us that when is the effective date of new labor codes? Right, 21st of November, government, notified these 4 labor codes. And at that point of time, people were telling 1st of April is the effective date. Then when 1st April is gone, now there is some other effective date. So there is a lot of confusion. A lot of clients are asking these questions. So let me clarify on the legal status today for labor codes. Labor codes are very much live from 21st of November 25. The laws were passed by Indian Parliament in 2019 and 2020, but the laws were notified by the government on 21st of November 25. So a lot of provisions of law are very much live from that date. 1st of April 26 was just a date which was provided by Labour Secretary at that point of time. And that was kind of misquoted or misunderstood by people that it's not effective from 21st November, rather it is effective from 1st of April. That's not correct. And that's the classic example we see today. The state rules are not in place. The central rules are not notified. So which means that law is effective. Most of the provisions are effective. The financial side of, we'll discuss about it. The provisions are effective, but a lot of HR related aspect or the non-financial aspects are not effective, where it is dependent on respective state rules.
Thanks.
We can do that.
Yeah, we can start with that.
What is the status in Karnataka?
So Karnataka, the draft rules are there, all the 4 draft rules, but none of them is notified.
So it's postponed.
It's not postponed. I would say it is just a matter of time. Maybe April, the rules may get notified. So I wanted to start this session with a question like, what is your awareness level in terms of, labor codes, how much you know about this topic? So my first option is I am a beginner. Maybe the audience on the call can write in the chat box. A, B, C, D, you have 4 options. B, you have a basic knowledge. C, you are aware of key provisions and have working knowledge. And D is you are expert in new labor codes. We have people from HR consulting. So I believe you will be in either C or D category.
No, B. So our key consultant, he would be C or D, but we are just like new at the we are learning. So I would say we are A.
Okay. Sir, what about you?
Between B and C, I can say.
Great. We'll come back with questions for you. Anyone in audience has replied?
Most of them are A, B.
A or B?
Yeah.
Okay.
Most of them are A.
Great.
is ruleless.
Great. Then I can at least try to add some value today because most of the audience is in A or B category. I keep myself in C category. So maybe a bit of insights I can give to the group. You can go ahead. So how legislatively or constitutionally the labor laws are placed in India? Labor comes under the concurrent subject, which means that the central government as well as the state governments are empowered to legislate on labor matters. There are a lot of entries in the union list and concurrent list which is provided. So accordingly, central government enacted 4 labor codes by consolidating 29 laws. And now the state governments have a role to play. They have to introduce their state rules, and that state rules, once notified, the law will be completely implemented. Today there is a partial implementation of law to the extent wherever there is no dependency on state rules, these provisions are very much live. Wherever there is a dependency on state provisions, may not be completely live. So accordingly, you will see there is a huge dependency on state rules for complete implementation. In terms of Karnataka, the 4 draft rules are already there in public domain, but the rules are not yet notified by the government. The same status is for the central government rules. The rules are there in public domain, which is under public consultation. I'll show you one article, also recent coverage on that. And the central rules are yet to be notified. These are some of the latest developments which have happened, in terms of labor codes. 21st November is the very important date because the date on which labor codes were notified. Then 26th of December, ICAI released some FAQs on the accounting treatment of labor codes. So this was a very timely intervention of ICAI because a lot of listed companies wanted to close their books from reporting perspective. And the clarity was required what kind of treatment should be there in terms of additional provisionings, in terms of gratuity or leave encashment and so on. And this was released. Then on 30th December, a lot of FAQs came from government, which kind of provided a lot of clarity on some of the aspects of wage, as well as the central rules were republished for public consultation. Then 9th of January, there was another FAQ which was released. 16th March 26 again is very important milestone. There another FAQ has come, and that FAQ provides some interesting insights on some of the areas of wages. So this is the coverage which came in media in November. 21st of November, the courts were notified. The Labour Secretary Vandana Gurmani madam came in public media, and she gave an interview that our endeavor is to make the laws completely effective from 1st of April. So there is no government document or PIB release which says that the laws are effective from 1st of April. The laws are effective from 21st of November. This was a statement from the Labour Secretary telling that our endeavor is to make all the rules effective. And you will see in the next slide the latest status which has come. This is the article on 2nd of April. So the Labour Ministry has cleared the draft rules, the central rules, but it is pending with the Law Ministry now at central level. So once Law Ministry clears, hopefully in few days, we can see at least the notified central Labour Code rules.
So before you move on, before the session started, we were having this conversation with Mr. Murali, right? So we discussed that the Karnataka rules are not come out. So what should companies do now? I mean, at a high level, and I'm sure there's a lot more we have to go through. So do companies sit and do nothing because the main provisions are out, but these central rules and state rules are not notified? Or they actively act on what has come out and then they deal with the rest, be prepared, but finally act on it when the rest comes out? What is the high level in terms of the approach?
So what happens, some of the provisions are very substantive provisions which are very much live. For example, the provisions in relation to wage, is very much live. Provisions in relation to gratuity is very much live. Leave related provisions are live. So at least in these areas, companies have to start working. If you have to align your compensation structure with the new definition of wage, that has to be taken care of. If people are leaving, between 21st November till 31st of March, and you are still paying gratuity on the older rules, you may have to pay incremental gratuity to them. There was a provision that as on 31st December, leave encashment was due for employees. So these are the provisions which are very much live. So any organization has to, look into what are the provisions which are completely operational and what are the provisions which are dependency on state rules. The provisions which will have dependency on state rules will be very procedural provisions, such as what kind of reporting will be there, what kind of registers will be there, how you will do filings, right? What kind of format of appointment letter will be there, just to give you an example. So very procedural kind of aspects will come. Substantive provisions are very much live. So any organization today, Vijay, they need to understand what are live, where they need to start working on it quickly, because laws are live with effect from 21st of November. If nothing has been done, it's already late, I would say. But very quickly, organizations had to pick it up. And as and when the state rules and central rules comes, do evaluation of the activities what you have already done. So this is on the screen you will see a broad overview of the laws which have got labor codes. So there are 4 themes. First theme is timely payment of wages, bonus, minimum wage, and so on. Second one is in relation to industrial disputes. The third one is very important, from employee sensitivity perspective. The employees in GCC, they may have a question, they may be coming to HR teams, what is the impact of labor code on my take home salary? Or the company may be interested in knowing what is the overall cost impact on me, right? All those answers you will get in this code on social security. You will, that's why I put, that green color, and these are the laws which are kind of applicable on a month-on-month basis when you do a payroll processing, right? And every employee gets impacted because of this code. And the last one, all the HR folks will be very interested into, because a lot of occupational safety and health and working conditions related provisions have been merged, and they are equally applicable to a GCC setup or any other setup. So organizations have to do something more, to align with this. There may be a need of updates to the HR policies, some sort of categorization of employees will be done, and that we'll discuss in the slides. Some data points from government, coming directly from government. These are copy paste from some of the government publications. So what government say that for employees in IT sector, some of the evident benefits are there will be timely release of salary by 7th of every month. We'll discuss on this very important point, because every organization may have to do some payroll related changes with this regard. We'll discuss that. Then equal pay for equal work. And women participation is strengthened, because there are a lot of committees and all where women participation will be required. Women gets additional protection in terms of working in the night shift. Then in terms of resolution of grievances, there are committees which are expected to be formed. And we will see about the guarantee of social security benefits. Probably India is one of the first country where gig and platform related laws were passed. After that, many countries replicated that, but at the point when this was passed, India was probably the first country. So we'll discuss about that as well. Now, one evident question which is, which comes to us from clients is that everything is beneficial for employees in terms of new labor codes, what we are getting out of it, right? But when we will see the provisions, it will look like the employees are only getting the benefit, but not be correct. See, it's like first time you are making a very big change in terms of labor reforms. So some initial hiccups will be there. A lot of changes will be required. There will be some pain which everyone has to bear. But like how GST came into picture, right? Initially, a lot of hiccups were there, but then it became a very smooth process. So what will happen once the process is streamlined, everything is in order? You can see this is the compilation of data which government has given. The number of rules which were there under these 29 laws was 1436, which will be only 351 now. Then number of returns which organizations were filing. If you were 100% compliant, then 31 returns were required to be filed. Now a single return will be required to be filed. Similarly, the number of forms, right? 181 becomes 73. Registers, very important. Month on month basis today under the labor laws, you have to maintain certain registers. So 84 registers were required to be maintained. That becomes 8 registers only under the new labor codes. Registrations, again, 8 registrations were technically required. Now single registration can take care of everything. Similarly, in terms of licensing, a single license can take care of things. A very important point is
Mute, please.
very important provision which has been introduced for the first time is compounding related provisions in labor laws. So very important. So the initial one-time transition, may need extra efforts, but once the system stabilizes, it can be a very smooth process. At least labor reforms can help you in optimizing your time and efforts going forward.
Cool. Just see, Prashanth, are there any questions coming in the chat? Nothing. So let me then play the spoil sport. So we have 4 codes,
Right.
and 2 of the codes, at least there's a perception in industry circles that it's impacting more on manufacturing side because it talks about industrial relations, it talks about occupational safety. But we are in a GCC focused conversation now.
Right.
What's your take on that, and what do you see is like sort of the key impact for GCCs?
Right. So let's understand the name industrial relations code, but how industry has been defined is very broad. So any service sector, any GCC will fall under the labor codes. Even word industrial would cover all of them. That's how it has been defined. Even today, when we see the laws, right, the courts have interpreted IT companies or GCC setups as an industrial setup for the purpose of Industrial Disputes Act. So very much the GCCs are covered under all 4 codes. One of the code has a dependency on headcount, that is Occupational Safety, Health and Working Conditions Code. The organization need to have 10 or more workers. But other than that, all the codes are equally applicable. And if any GCC is scaled up GCC, you have 10 or more workers. And all 4 codes are very much. And once the codes are applicable, you are bound by all the provisions of the law. It is the law of land. Now we have to accept that. So there is a lot of feedback we get why we should do that. We were anyways compliant. See, the laws are changing. You have to comply with it. Whatever operationally changes are required, you have to do that. It's a one-time transition issue which you have to bear with government.
Thanks, Ankur, for addressing that.
So what we will do, we'll discuss one of the very important part of our discussion today. We'll talk about the introduction of the concept of uniform wages under the 29 laws which have got subsumed. Earlier, what used to happen, there were 29 different definitions of wages for 29 different laws. And it was a very big issue in courts. Every court were interpreting one component as included, other component as excluded. Now, one single definition will work across whatever laws have been subsumed. So how wages have been defined, we'll see that, and we'll spend some time here. If you have any questions, please do ask, because this, I feel, is the heart of our discussion. If we can understand this concept, most of the queries may get resolved. So how wages have been defined? It is like an all-inclusive definition. It says that all remuneration payable by way of salary, allowances, or otherwise. So or otherwise makes it very broad. Whatever you are paying to your employee kind of gets covered under the remuneration. Capable of being so expressed in terms of money and includes. So it says and includes basic pay, DA, retaining allowance. Now, a lot of HR folks, right, what they are taking interpretation, they're not reading the first 2 lines. They're just telling wages means basic pay, DA, and retaining allowance. That's a very incorrect interpretation. Had that been the intent, first 2 lines would not be there in the wage definition. So which means that it's an inclusive definition. In law, wherever there is an inclusive definition, wherever this word comes and includes, that is just for clarification purposes. So the law clarifies that everything you pay to your employee is remuneration or wage. And it also includes these 3 components: basic pay, dearness allowance, and retaining allowance. It does not mean that only these 3 components are included components. So once you arrive at remuneration by adding all possible components, then you will see there is a list of 11 specified exclusions. So any of your component which is under the exclusion list, that will be eliminated from the number what you calculate above. So what are the 11 specified exclusions? Bonus payable under any law, which would mean statutory bonus. Then value of housing, accommodation, and utilities. So some of the housing, like for example, you give a house facility to a senior employee, right? That can get covered here. then value of employer's contribution to PF pension, conveyance allowance or value of traveling concession. Again, value of traveling concession is different interpretations are being taken around it. Then sum paid to defray special expense to nature of work. What constitutes defray special expenses is not defined anywhere in the law, but similar language was there under the ESI Act. And there are a lot of precedents around that, which kind of says that if there is a nexus with a expenditure which is related to your work, then it can fall under defray special expenses. One classic example could be a uniform allowance given to someone who works in factory. So there is a clear nexus of work with that expenditure, and accordingly that can be treated as defray special expenses. Then the classic one, house rent allowance, always this has been an excluded component in many laws. So HRA becomes excluded. Then remuneration payable under any award or settlement. So this is also interesting one for manufacturing setups, at least not very relevant for GCCs. What happens in manufacturing kind of setups, there are settlement agreements and some correlation exists with that settlement agreement here. Then any overtime allowance. So there is a FAQ which came that clarified how this overtime allowance will be treated. Commission payable. And last two in red are the terminal benefits when employee separates gratuity payable and retrenchment compensation. Right now, what happens out of these 11 exclusions, if I leave the two ones in red, the 9 exclusions total of that cannot exceed 50% of my remuneration. So again, I want to clarify this 50% is like the exclusions are capped at 50%. Inclusions are not capped at 50%. So a lot of folks are taking a view that I make my basic at 50 and I am done. I don't have to do any changes. So let's say my wages are 80, but I will do contribution on 50. That is not correct. It is like exclusions are capped at 50. So if exclusions are 20 out of 100, then your wage will become 80. Exclusions are 60 out of 100, then your exclusions will be capped at 50. We'll see that with a couple of examples also. So 50 is for exclusion, not for inclusion. That let's be very clear on that. There's no doubt about it. One more point I want to tell, one common component which you will find in all GCC compensation structure is special allowance, which is the balancing figure of your compensation. You can call it special allowance or personal pay or other allowance or whatever name, right? And there is no exclusion under these 11 specified exclusions, which means that if basic is 40, 20 is HRA and another 40 is special allowance, your wage will become 80 just because of that special allowance. So by virtue of that special allowance, some sort of restructuring is required by the organizations. We'll see that in the example. There are two FAQs which have come, very important FAQs on, clarification of what should be included, what should not be included. So one FAQ came which said that any performance-based incentives, because this was a long pending demand of industry, like you pay bonuses and all one-time bonuses. So if you pay that could be a real, challenge in terms of calculation of wages. That particular month would have been a very high wage amount. So these performance bonuses are removed. Variable part of component is removed. ESOPs, if you are paying to your employees, will not be considered for wage, and any reimbursement-based payments will not be considered for wage. And it also clarified that leave encashment will not form part of it. Now, another FAQ which came on 16th of March, again, very important one. Like it was not clear that the monthly gratuity contributions or monthly ESI contributions, what are being made, whether that should form part of remuneration or not. So this FAQ very, nicely they clarified that the monthly gratuity contribution, which forms part of your regular CTC or compensation, or the ESI what you are contributing, that goes out of the wage calculation or the remuneration. But whatever is mentioned in that wage exclusions, such as PF, pension, statutory bonus or overtime, right? Those will be considered for the purpose of wage calculation. And they also gave a couple of examples on what do you mean by remuneration in kind. There was a part of wage which we did not discuss, is remuneration in kind. So they also clarified food coupon would consider as a remuneration in kind. Typically, we see food coupons in GCC compensation structures. So wherever there is a food coupon, there will be slightly different way of calculating wages. And that will be added as per the 15% rule, which is provided in the wage definition. So let's understand, this concept with a couple of examples. In this case, basic salary is 40% of total remuneration. A typical GCC, again, compensation structure. HRA is 50% of basic salary. LTA is 16,000 and special allowance is 24,000. So what would be the wage in this scenario? Any guesses from the audience? A, B, C, D? Anyone from you?
1 lakh.
Sorry?
It should be B, 64,000.
Yeah. Other than B, anyone with A or D or C?
Should be D, no? 1 lakh.
So we have one answer as D, one as B. Is there any guesses from you, sir?
B and 64 we are receiving it.
B64. B64 is the right answer. Most of the people have answered for B. That is the right answer. So basic salary plus special allowance, 64,000 will be the inclusions out of 100,000. Because HRA and LTA, HRA we discussed is the exclusion. LTA is, it's written conveyance or value of traveling concession. So if we consider value of traveling concession as LTA, then 16,000 also will get excluded. Accordingly, a basic salary plus special allowance, 64,000 is the right answer. Now, what is the impact because of this? Gratuity you were calculating today on 40,000 rupees. Now, once wage gratuity will be calculated on 64,000, and there are many other benefits, but I'll talk about gratuity first. So your base is changing from 40,000 to 64,000, and accordingly, almost more than 50% increase in terms of gratuity cost will arise for this organization in this current structure. And why this problem is happening? Because special allowance exists in this compensation structure. If this special allowance can be optimized, because wage anyways has to be 50 at least, right? So that extra 10,000 plus 14,000 is extra coming in special allowance. Some sort of restructuring if we do, then that can help in some sort of optimization of wages. Any questions here? We can go ahead. Another example, similar kind of numbers. Here, HRA is 28,000, conveyance is 28,000. These are the two exclusions. So what will be the wage in this scenario?
44,000.
So we have one answer D, 44,000. What are any other guesses here? Any guesses we have?
This is the previous ones.
So we have one answer D. Anyone with B or C? So 44 is not the right answer here because 40 plus 4, 44 are the included components. But then there is a 50% rule. So out of 100,000, at least 50% should be wages, which means that 50,000 will be the right answer. So this is the example, classic example where 50% rules applies. But 50% rule will not apply by default in all the cases. That is what I was telling initially, that exclusions are capped at 50, inclusions are not capped at 50. So by default, 50% rule will not apply. In very rare cases, 50% rule will apply. And that's why in this case, you will see 40,000, then wage becomes 50, 6,000 becomes your deemed wage in this case. So very aggressive planning will not help any organization in reduction of wages. Law mandates that at least 50% of your remuneration should be wages. So we'll proceed.
There's
Now,
one question that has come up. Where does leave encashment fit in and variable pay based on performance?
So that FAQ clarifies that leave encashment as well as the variable pay, both of them will not be considered for the purpose of calculation. We'll discuss, some of the important points on code on wages. What are the changes which are coming because of code on wages? And from payroll side of it, very important changes, it has to happen. We'll take up one by one. First point is timely payment of wages. So wages have to be paid by 7th of subsequent month. Now, what is the impact of this provision? Let's say any employee who joins your organization after the payroll cutoff date, right? So let's say payroll cutoff date is 20th of April and someone joins on 25th of April. Then ideally the person was typically paid salary by May end, right? Along with May salary, he or she was getting the salary. Now what will happen? You have to have a process where this particular person, gentleman or gentlewoman who is joining, she should get or he should get the salary by 7th of May. So you need to have some sort of supplementary payrolls in the organization where these people are enabled to get that wages for 5 or 7 days, whatever they are earning after the payroll cutoff date. Another important point, the last one on this slide is full and final settlement of wages in 2 working days. So very, very, challenging provision, but that's how the law states that the wages have to be paid within 2 working days of employee leaving the organization, within 2 working days of last working day. And this kind of provision was there in the law earlier for, mandatory separation. When you were terminating the employment, this kind of provision was there. Now this has been extended to voluntary resignation cases also. So this is a very significant change. The payroll systems have to be made robust in such a way that you comply with this provision. I will tell you one interesting point here. When you read the law, right, law provides a relaxation where it says that state government can come up with some relaxation. But unfortunately, if I read, let's say, Karnataka draft rules, there is no relaxation which has been provided. So this can be a real, challenge, but we have to find out ways to come out of it.
Ankur, so since it's a substantive provision and not exactly a procedural one, and now that we've had things in place for 3-4 months now, have you seen how existing GCCs are dealing with this?
So 2 things here. First and foremost, there is a dependency on state rules here. If any organization has still not switched, they can take an argument that the state rules provides for relaxation and that has not come. So that's why we have not made the change. But having said that, the organizations are coming up with innovative, solutions to this problem also. First and foremost, what used to start after the last working day, that process has to start when employee resigns, the day when he or she puts down, right? So that is one solution, because you get sufficient time of 30 days or 60 days or 90 days to do all sort of calculations. Then for larger GCCs, right, you cannot keep on doing this every second day or every day. Let's say every day someone resigns, it becomes a full department. They are fixing 1 or 2 dates. They are aligning the last working day in such a way that some loss of pay can happen, or they are managing it with employees where only on 2 days employees will be released in the organization. So then at least these iterations can be reduced to some extent. Another important point here is that this says wages have to be paid within 2 working days. It does not say, non-wages have to be paid. Everything has to be paid. So for gratuity, you have 30 days of timelines. Leave encashment is 2 days only. But anything which is non-regular payment, right, which does not constitute wage, for example, we discussed about variable pay, there can be other components, one-time payments, all those can be paid at a later date. In 2 days, you have to pay regular monthly components, which you are paying to the employees. On minimum wages side of it, right, again, there are some good changes which are coming. There is now a concept of national floor wage, which will come. By national floor wage, it means that the central government will fix a national floor wage. It can be, geographically, location-wise or regional national floor wage also. Once that is notified, the state government cannot issue a minimum wage below that level. So at least at floor wage or more than that, the state government will be doing. So this may result in increase of minimum wages in some of the states. But as of now, we have not seen the notification. The earlier notifications are continuing. Once it comes, this has to be interpreted how it will culminate. Another important aspect under minimum wages is that till now, under only for people who are falling in the scheduled employment list of that particular state. For example, in the state of Delhi, Shops and Establishment Act is covered under scheduled employment, which means that anyone under shops and establishment was also covered under minimum wages. There will be many other states where shops and establishment is not covered. So a lot of people, were left out of minimum wage coverage because they were not falling under scheduled employment. This concept is now abolished. There is no concept of scheduled employment, which means that ideally everyone gets covered under minimum wage. Now, in terms of normal working hours, there are timelines which have been given: 8 hours of work and 1 hour of rest. Then it can have some, conflict with the state shops and establishment acts. There are provisions for overtime if there are more than 8 hours of work. Government has, given a list of authorized deductions from your salary in a particular month. You cannot have more than 50% of deduction from the salary what you pay to employees. So organizations which have a lot of, loans and advances policies, they have to be very careful around it. Very important change in the last point. When you are paying to contractors, right? Earlier, the process was when an invoice is raised by contractor, then you will be making the payment. Now the contractors have to be paid by 7th of the succeeding month, at least for the wages part of wages of the workers who are working with you. That part has to be discharged by 7th of next month. So this is one change where some sort of commercial renegotiation with the contractors may be required. Yeah, Social Security Code is, most of the media articles are talking about the provisions of Social Security Code, because these are the areas where employee gets impacted directly, right? Their take home can get impacted. So I'll clarify, on some of the aspects of Social Security Code. First and foremost, there is one notion that because of the increasing wages, right, PF will increase. And if PF increases, employees' take-home salary will reduce drastically, right? Because 24% of wherever you contribute on basic salary, 24% of your wages will go towards PF. So that is not correct. Even today under the PF Act, 1800 rupees, that is 12% of statutory ceiling of 15,000 is what is required to be paid. Beyond that, what you pay, that is when you pay at the rate of 12% of basic salary, that is more of a voluntary coverage. And that's why today also you pay on basic salary, not on PF wages, right? So that process can continue. There is no need to, panic about PF getting increased for employees. If a structuring is done properly, there will be no reduction in PF contributions or increase in PF contribution for employees. The Labour Ministry has also clarified on this aspect. There was a communication which was issued. We will show you that. In terms of ESI, also very, very interesting, discussion going on. Typically, what happens today is gross salary of 21,000 rupees. Now it will be on wages of 21,000 rupees, which means that people where gross salary was between 21,000 to 42,000, right? Because wages can be 50% of gross. So typically between the annual CTC of 2,52,000, that is 21,000 into 12, to 5,04,000. This is the class of employees which can get covered under ESI. So it is expected a lot of new people in the salary range of up to 5 lakhs or 6 lakhs per annum can get covered under ESI coverage. So there some sort of, if a proper restructuring is done, this can be avoided to a larger extent. So people where ESI was being contributed, you can still continue. Where ESI was not being contributed, by virtue of labor code, some people will get covered, but that can be, avoided by doing some optimization in compensation structure. Another interesting aspect is that ESI contributions, initially ESI department issued communication that you need to immediately do this change. So because more people will get covered in terms of compliance, you start bring more people in ESI, start filing the returns. But then ESI department issued another communication which stated that as of now, no change is required. Status quo needs to be maintained. We'll discuss, we have those notifications. We'll show you that. Another very, a point of, I think someone raised that question, that gratuity has to be paid after 1 year or gratuity has to be paid after 5 years of service. So gratuity eligibility continues for 5 years of service. Someone who is a regular employee of an organization, they will get gratuity only after 5 years of service. 1 year of gratuity eligibility is only for a set of employees who will be called as fixed term employees. So any employee you are hiring for a fixed duration, which is 12 months or more, if they fall under that category, then only gratuity entitlement is after 1 year of service. Otherwise, gratuity provisions will continue as it is, how it was there. The numbers may increase because of the formula or because of the base. The entitlement will not change for employees, right? And this is one area where, for the year end, so we are already in the next financial year, you have to close your financials. So gratuity provisionings will have to be done. You have to take actuarial valuation for the gratuity. So this is one area where we have to be very careful. Now gratuity will not be calculated on basic salary. It will be on wages. So when the inputs will go to the actuary for calculation, it will be on wages. And then, if your wages are high, the provisionings will become high. So this is one area where the accounting teams, the auditors also should be involved when this exercise is being taken care of. Some procedural, requirements here. There is a very good development which has happened. There is a 5-year period of limitation which has been introduced under PF and ESI. Earlier, under the PF Act, there was no period of limitation. So even 10 years, 15 years old notice could have come. So this is a very good development which has happened. This will, kind of give some sort of cushioning to the GCCs. There is also a very good welcome provision which has come, that while earlier voluntary opting in for PF was there. So a small GCC which comes into India, let's say with 5 employees or 7 employees, you always have an option to get into the PF compliances by opting voluntarily for it. But there was no option of opting out of PF. At least there are now enabling provisions that organization can come out of PF and ESI coverage as well, right? So if you become very small, the compliance cost is more than the benefits. This is one area which can be explored in due course of time. And as I stated, there is a separate chapter which has come for the organized sector. So detailed provisions for platform workers, gig workers, domestic workers, aggregators has been introduced. So now the entity which will be considered as aggregator, they will be responsible to contribute towards something called a social security fund that will be used to help these platform and gig workers.
Yeah, just hold on. Ankur, so do you see any impact of the unorganized sector changes on GCCs?
If you are in that kind of model, so for example, a Zomato, right? If Zomato kind of model is there where you're providing a platform for some sort of work, through platform you're securing some activities, or you have an app where you become an aggregator, you get business through the app. If GCC is in that kind of business, then yes. But if it's a back office providing services, then this provision may not be applicable, Vijay.
And how are you seeing it? I mean, it talks about domestic workers.
Yeah.
What about international workers?
A very interesting point. So PF law was not having any provision for international workers. Code on Social Security also do not have any provision for international workers. So new EPS and EPF rules are getting drafted by government because there was a 1-year transition window. I'll also show you one more screenshot. So it is expected once the EPS and EPF rules 26 will be released, right? That time there will be provisions for international workers. So all of us are waiting for that because there is an anticipation that if the understanding what we have with that, IW related contributions will reduce because the wage under labor codes is narrower than the wage which was there under the PF Act.
Right.
One more point here, because we are discussing about PF, you must be aware of that Supreme Court had passed an order which kind of nudged central government to increase the wage threshold for PF. So that order was passed on 5th of January, right? Three months window was given. So ideally by 5th of April, government has to come with a new wage threshold for PF. We have to see when it will be, announced. So some change in PF wage threshold of 15,000 may get updated in next few days because of Supreme Court order. So this is the communication which I was referring to. The communication very clearly states that there will be no impact on PF because of new labor codes. If you want to do a voluntary contribution, on wages, you are most welcome. You can do that. But otherwise, you are not required to increase the contribution. Now, this is the screenshot which I was telling last week. This was a communication from EPFO. They released a video. So what they're telling that existing EPF, EPS and EDLI schemes will continue until new schemes are notified or till November 26, whichever is earlier. So there is a section 164 under the Code on Social Security which provided a 1-year transition window for PF. So that's why any change also, if PF has to happen, you will not do anything. You have to maintain status quo for PF till these rules are notified or till November. Why November? Because November those codes were notified. So that's why that 1-year window will start from November. Now, this is very important, point. If any GCC employs people where employees are up to a salary range of 5 to 6 lakhs, CTC of 5 to 6 lakhs per annum. If you see on the left side, right, on 11th of December, this was the communication which was issued, and just read the last 3 lines. It says that a large number of exempted employees in a covered establishment is likely to be brought back covered under ESI coverage with the new definition of wage. That is what I mentioned, right? That is going to happen in future. So they kind of looked like that immediately this change has to happen. But immediately, on 18th of December, after a week, they mentioned again the last 2-3 lines in that communication on right side. It says that the central rules and regulations are yet to be notified. Further action for the compliances will be done in accordance with notified rules and regulations in this matter. So net, you have to maintain status quo for ESI. You have to maintain status quo for PF till further communication comes from department. And this is, I feel personally, this is one area where a lot of mistake industry will do, because traditionally we have been, we are used to this fact that okay, gross salary is 21,000, person will not get covered under ESI. Gross salary less than 21,000, people will get covered under ESI. Now you have to do correct ascertainment of wage. Based on wage, the right person has to either fall under ESI net or he has to come out of ESI net based on the wage threshold of 21,000. This is some, to make it more interesting, these are some of the media coverage in Q3 when these companies took a provisioning. So TCS took a provisioning of 1,800 crores for gratuity for Q3. When, like to that extent, the one-time impact they took was 1,800 crores for the gratuity hit. So this kind of also answers a lot of people, argue that labor codes are not implemented, or 1st April it should have been implemented, or right now also the rules have not come, it is not implemented. So that's not correct. Gratuity is a classic example. The dependency on state rules or central rules are not there, at least in terms of payment of gratuity. So that is very much live, and that's why these listed companies have taken a hit of such big numbers in those quarters. Now coming to the next code, Occupational Safety, Health and Working Conditions Code. This is one code I told you. A lot of HR related aspects, will get impacted. One very important ascertainment which has to be done under this code is classification of employees between workers and non-workers. And just to give you a historical background of this, the Industrial Disputes Act has this concept of workmen. The same definition was there under the ID Act, which has been copied pasted here. And the nomenclature of workmen has changed to worker. But what used to happen, in order for an employee to avail the benefits under the ID Act, you were supposed to go to court and you were supposed to raise a dispute. You were supposed to prove that you were a worker or workman under the ID Act. If court upheld that you are a workman under the ID Act, then only the person was responsible to get benefits under the ID Act. Now that process is kind of being passed on to employer at first level. It is the responsibility of employer to categorize employees on day one as worker and non-worker. This is a very important ascertainment because, some of the provisions such as leave encashment related provisions are related only to workers. So today, if you have to take a provisioning for leave related balances, the leave related aspects under labor codes impact only worker population, not the non-worker population. So this ascertainment is very important ascertainment, and this is one of the area, Vijay, you were telling what are the immediate steps. So worker versus employee along with a compensation optimization is one of the immediate area which GCCs have to look into. And this is a tricky exercise. It's not a very straightforward black and white exercise, because what it says is that any person who is not having managerial role, administrative role or supervisory role, they will become worker. But what constitutes a managerial role or administrative role or supervisory role is not defined under laws, neither under the old laws nor in the new laws. It is, completely an interpretation issue. But there are a lot of precedents under the old ID Act which can be relied upon for this exercise. So typically a IC role, right, independent contributor role with a very high salary also, maybe a 5 lakh rupees per month salary also, can become a worker by virtue of this definition. So the roles and responsibilities becomes very, very important. If the roles and responsibilities indicate that person will not be worker, then it is fine. Otherwise, a plain IC role with salary threshold becomes irrelevant for them. So very, very important exercise which organizations have to do in advance, because a lot of entitlements are dependent on this worker versus employee assessment.
Have any of the FAQs addressed this? Is there
No,
any-
unfortunately, no, Vijay. FAQs have not addressed this, and I doubt any FAQ will come on this matter, because this is one area where a lot of legal disputes happen. So any FAQ government releases, the companies will rely on it, and government can get into a back foot there. I don't believe they should. Ideally, they should bring it, because the dispute should be less going forward. But then if they bring FAQ, there will be challenges from legal perspective for government. So some clarity should have been there. There is a wage threshold. You will see 18,000, but that is only for supervisory role, which means that managerial role and administrative role, there is no wage threshold, right? So that's why this is a tricky exercise, very subjective exercise, but it has to be done for for closure of your books, for leave provisioning, for ascertainment of other benefits in the organization. We'll discuss some of the committees are dependent on the number of workers to take a standing order that depends on number of workers in the organization, and so on. Any questions we have? Perfect. So I discussed this point, a smaller GCC, right? You can completely come out of this code if you have less than 10 workers. So for example, you have 20 employees, but the worker population is less than 10. Then ideally you can come out of this. This code will not be applicable for you. For larger organizations, obviously this code will be applicable for you. Then there are provisions for workers. Again, they define the number of daily hours. Overtime has to be paid. So very important point again from GCC perspective. Typically, we have seen GCCs do not have this overtime related concept. Now, the overtime related concept is statutorily being introduced for all the organizations. So OT related provisions, policies, process, everything has to be introduced in the organization. Again, one challenge which I have seen working with GCCs, especially the smaller GCCs, is that you don't have a time tracking mechanism. If you don't have a time tracking mechanism, you cannot track overtime. So some sort of time tracking mechanism also will be required for the organizations. Leave is a very important point. Till now, for GCCs, leave-related provisions were coming from the respective Shops and Establishment Acts. And the Shops and Establishment Act talks about various kinds of leave, casual leave, sick leave, earned leave, and so on. Labor codes talks about only earned leaves, right? And that too for the class of employees who will be called as workers. So out of total population, the non-workers will be governed by Shops and Establishment Act. The worker population will be governed by the leave provisions which are there in the OSHWC code. So very important concept, because this is one area where immediately, again, some changes have to be done by the organization. It does not have dependency on labor code state rules. What it says that 1 day of work, 1 day of leave for 20 days of work has to be given. So if I broadly interpret it, it is 18 days of leave per year, which is aligned to Karnataka Shops and Establishment Act. Leave carry forward is up to 30 days. In Karnataka Shops and Establishment Act, it is up to 45 days. So some alignment has to happen with the state laws. Another last 2 points are very, very important. There is a provision of leave encashment on an annual basis if the accrued leave is more than 30. So let's say a worker has a leave balance of 40 days, then 10 days of automatic encashment has to happen as on year end, that is 31st March. This analysis has to be done and automatic leave encashment should happen for those 10 days. And then there is another provision of leave encashment on demand. So even if there are less than 30 days, a worker can technically go ask the employer to encash the leave for less than 30 days of accrued leave, which is there. These provisions are very new for a GCC setup. If I, talk Telangana Shops and Establishment Act, they have a provision of 8 days of annual leave encashment. But other than Telangana, very few states may have the annual leave encashment related provision. But for instance, a GCC which is based in Karnataka, right? The annual leave encashment provision is very new concept for them. The always leave encashment was there at the time of separation of employees. Annual leave encashment provision is a very new concept. So this is one area where we have to digest it also and implement it also in the organization. Any feedback, Vijay, on this leave provision?
It's going to be interesting, I guess. I think there's a lot to deal with, right? If you look at almost every code, and even though, as we discussed in the beginning, some of the codes in the face of it don't appear to impact GCC,
Right.
but you look at the fine print, they all have an impact.
Very much.
So there's plenty to be done.
Right.
We have a couple of questions which
Please,
are coming in.
please.
So I think this is of the earlier code. So I'll just read out.
Yeah,
what
sure.
Maybe you can. Do you see FTE model becoming less attractive engagement model considering the increased social security liability?
So there are two views for that FTE model. For the benefit of audience, again, I'll tell you what is FTE. If you hire someone for a fixed duration of 1 year or more, they become your FTEs. But then that set of employees should get equal benefits, what your regular employees are getting. So one view is that gratuity liability will arise, so it becomes less attractive. But other view here, and this comes from a government, document. Other view here is that after 1 year, there is automatic termination of employment. So let's say you hire someone for 13 months over, automatic termination. You don't have to give any notice period. You don't have to give any severance pay to those set of employees. So separation is very easy there. There is no legal hassle because contract is over, employment is over. The person cannot go to court for that. So both the views are there. Some cost impact could be there, but at the same time, it is very hassle-free kind of arrangement. And it kind of, it is a evolving concept with the new age employees coming to the workforce. You may not want a very big commitment, right? And companies also may need people for specified projects. So I have seen one of my client into government projects. So they hire people for just 2 to 3 years, specialized people to work on a government project, 3 years, project over, employment terminated. But when earlier the termination was happening, the entire, gamut of that severance pay or retrenchment compensation, the notice period, all those things got triggered. But now that becomes easier for the organization.
Right. A couple of more ones are there. Should subcontractors be considered as FTE? Alternatively, people who are not working regular time, maybe I guess not exactly following the language, but what I understand, if they're not working, let's say 8 hours, will they be considered as FTE?
Right. So very common question which is coming that people who are contract workers, right? They go and work at a client site. They work for 1.5 years. So whether gratuity, and a lot of people feel that, I'll tell you that FTE provision will be applicable. So whether the provisions of FTE is applicable in that arrangement, which means that the contractor or the principal employer has to pay gratuity in this arrangement. 1.5 years someone goes and work. Both the concepts are very separate. The contract worker is a very separate provision and FTE is a very separate provision. And if you read the finer details, the definition for contract worker, you cannot apply because how you will give equal benefits to a contract worker as similar to your regular employees. And this view we were always taking, this view was affirmed by the FAQ which came on 16th of March. So everyone listening here, this is very now clearly made publicly available by the government through FAQ that if anyone is a contract worker, FTE provisions will not be applicable for them. So there is no corresponding increase in terms of gratuity for people who are contract workers because they will not classify as fixed term employees. Obviously, some sort of ring fencing and contract reading you have to see, because your contract should not have an element of everything, right? They were treated as employee also, they are treated as contract worker also. If it is properly drafted, contract where a person is going to principal employer's place to work as contract worker, he or she will not fall under FTE provisions. And part-time employees are very much like employees. They will get the prorated benefits in the organization.
But practically, do you see swipe in, swiping out, that kind of stuff becoming an issue?
So basically, the labor codes have not specifically addressed about this part-time thing. There are provisions for hourly rate of work and all, but let's say someone is hired for half day, right? Ideally, all the provisions are kind of equally applicable for them. But yeah, that prorated, how overtime will be calculated and all. Earlier also it was not there, and here it has not been clarified, at least explicitly.
Do we have time to take a few more, or should we move ahead with the slides?
We can take.
Yeah. I think only 2 more. If HRA percentage varies between employees in approximately the same band role, do you see any issue from the viewpoint of ESI applicability?
So ideally, a lot of companies are taking HRA as balancing figure of compensation now. Earlier, special allowance was the balancing figure. Accordingly, if you take that position, then HRA will vary from employee band. And accordingly, whatever wages comes, you have to contribute on that. So the ESI also will be calculated on that level. And just to add, wages can vary from month to month. It's not that it's a fixed number which will always be there for 12 months. It can vary. Earlier also it used to vary. Let's say you get arrear bonus, arrear salaries and all, then that month wages were higher contributions used to happen.
Now suddenly a lot of questions, but some of it seem to be repetition of what we have discussed. Is the ESI threshold of 21,000 still there to follow, or will it go up basis the wage if it goes beyond 21,000?
That is what I discussed. So earlier 21,000 was on gross salary. Now 21,000 is on wages. And that is what the December year communication. So, which means that technically someone with a gross salary of 42,000 and there the wages are at 50%. Till that level, people can get covered under ESI. And a lot of new people will get enrolled for ESI. I understand from some of the clients, they already did the changes. New people were enrolled. That is correct or not correct is, the time will tell. But many people were enrolled in due course of time for ESI.
But I think many of the questions seem to be repetitive. I'm not sure whether they were there during the full call.
The last point here, I'll take Vijay, very important point, again from GCC perspective. So there is a provision of annual health checkup for, employees. Now, there's a misconception that everyone is covered under annual health checkup. GCC has to mandatorily introduce an annual health checkup policy. As a best practice, you can always have it, and a lot of GCCs have that. But as a statutory requirement, you are not required to have annual health checkup for all the employees. Firstly, the respective states will classify the set of employees. So a Karnataka-based GCC will not be required to have any, because in Karnataka, the specified class is factories, mines, and plantation workers. So for GCC, which is in Bangalore, providing IT-based services to other entities, annual health checkup related provisions from labor codes perspective will not apply. Some other states may have different criteria, like some states have age threshold, some has worker threshold, those conditions are there. And state to state, the procedural mechanism will change. There is an extensive list of what are the tests, what are the diagnostic tests, how the medical practitioner will certify. There is a format which is given, very granular details are provided. So this is one area you cannot have a blanket approach. You have, a state by state approach and as required as per the state requirements. Another very important point where a lot of work will come for HR folks is issuance of new appointment letter to your existing employees. So there is a format which has been issued by government. Form in Karnataka OSH rules, it is Form 6, right? But it is in the draft mode as of now. Within 3 months of codes becoming effective. Codes are already effective and 3 months we are reaching. but the rules are not effective. So if I read it liberally, within 3 months of Karnataka rules coming into effect, right? Every employee who is there in the organization should also get a new appointment letter. So for example, a GCC has 1000 employees, you need to issue 1000 new appointment letter in the format which is given by the government. And in that format, you may have some of the fields which are not there in your HRMS. So you have to also collect that data from those set of employees. So this is one procedural aspect which GCCs should keep note of. And this is one area where some activity will be required in due course of time, and some preparedness towards it can start today, because if data pointers have been mentioned, it is that collection of data can start today. Right. Another very, very important change which has happened, a very new kind of change. There is a prohibition of deployment in core business activities. For example, a GCC needs someone for coding. Right, coding can be a core business activity for that entity. Earlier, the practice was we have seen even 50-60% of the population were through third-party contractors. That has been prohibited. The law says that there is a prohibition of deployment of contract labor in core business activities. So this is one area you have to keep in mind. If you are a new organization, you want to have people through third-party contractors, then this provision should be kept in mind. Otherwise, there will be a violation. Some provisions, are there with regard to exceptions. So it says that if historically the work has continued or ordinarily the contractor has helped the organization, then this may be allowed. Or if the work does not need full-time people, or it's an intermittent nature, or sudden surge in demand is there, volume of work, then this is allowed. But otherwise, there is a blanket prohibition. So if you want to start a new process where you need people through third-party vendors, that may not be permitted. But if you have a substantial, you can demonstrate substantial history, you have always taken help of contractors, then you can, go with that exception. Otherwise, this is one area where you have to very seriously look into your manpower deployment strategies, your hiring strategy, whether you need to have people on your roles or you want to have people through third-party contractors. A very, very significant change, which can have a huge impact on GCC.
Are these defined, Ankur? Core, non-core?
It is defined, Vijay. So there is a list of, activities which have been given. So some activities they say will always be non-core. For example, housekeeping, security, right? Packing, unpacking in factory kind of setup, loading, unloading. These activities will be non-civil construction work, right? This will always be considered as non-core. So when a GCC is having services of a security agency or a housekeeping agency, there you don't have to worry. That will be considered as non-core. But let's say you are hiring people for coding, your accounting work, your HR work, that may be prohibited under this new provision. So one area to watch out for. Then we have provisions under Shops and Establishment Act, which provides special protection for women when they work in the night shift. That has also been institutionalized by putting the provision under the OSSWC code. In terms of committees, right, the law has provided various employee or worker related committees, which earlier was applicable maybe only for factory setup, but now GCCs also have to have this kind of committees. So one of the committee is safety committee. So each state has their threshold. Karnataka has not given the threshold, center has given 500. So Karnataka will have 500 workers. And I told that time, right, that worker versus employee assessment has to be done, because you will not know whether, let's say you have 1000 employees and you don't know how many workers are there, how many non-workers are there. So you may not be able to apply this provision correctly. So that assessment has to be done. Let's say in Karnataka, you have 600 workers in the organization. Then a safety committee has to be formed. There is a composition which has been given. The workers will be there, representation from other sectors, women representation will be there, and so on. So accordingly, these are some of the new requirements which GCC should watch out for. One is safety committee. We will discuss about grievance redressal committee as well in the next slide. Again, IR code, Vijay started with this point that as per the name, it looks like GCCs. For GCCs, it may not be applicable, but that is not correct. For GCCs, IR code will be applicable. There is no threshold also which is given there for applicability. So one of the provision, right, the first one in terms of retrenchment. So earlier the threshold was 100. This is one area where trade unions were not happy when government introduced. So now retrenchment in an organization where less than 300 workers are there can be done without government approval. Earlier, the limit was 100. So that relaxation government has given. Standing order for service sector is also very important for, mid-sized GCCs, because whenever you have 3 or more workers, you are mandatorily required to take a standing order now from government authorities. Earlier also, technically, this provision was applicable for GCC, but it was not very implicit. It was kind of, it has now been brought out very clearly that service sector has to take these standing orders if you have 300 or more workers, not employees. Then this worker reskilling fund is related to retrenchment. If you are retrenching employees, then this 15 days of worker reskilling fund has to be introduced in the organization. The last one, grievance redressal committee, again is very, very important because the threshold of workers is very low here. Any organization which has 20 or more workers, right? They have to have something called as grievance redressal committee. So this provision was there under the ID Act, but there it was an option given. So either you can have a grievance redressal mechanism or you can have a grievance redressal committee. So generally GCCs used to have a grievance redressal mechanism or a policy for grievance redressal. Now you also need to have a committee in the organization, which will be called as grievance redressal committee. The composition, powers and all have been provided. This can conflict with your, if you are working with global, servicing your global companies, they may have some, global grievance redressal committees as well. So some sort of alignment from law perspective has to happen with regard to grievance redressal committee. You can, right? Any questions we have so far, or?
I think now we'll open the floor up. We've read out some of the questions which we saw on the chat window. But before we sum up, if anyone wants to raise any questions, please feel free. So you can unmute.
I think, yeah.
It's you unmuted, right?
Please unmute yourself.
So this is the slide where we'll discuss what are the immediate steps which are required, from a GCC perspective. But before that, if you have any further questions, we can take it up. Otherwise, we'll go to this slide.
It's a mass layoff, 10,000 people going, 12,000 people going on Sunday. What would happen settling those wages in 2 days?
So sir, even today, prior to labor codes, right, that provision was there. If you are doing a layoff, you have to settle within 2 working days. Problem was, I'll tell you what was the problem. Law was not very strong. It was like a toothless tiger. Now the law has inbuilt provisions where there can be repercussions like anything. So law says that it's a graded kind of mechanism of non-compliance. First time you will end up doing monetary fines. Second time imprisonment related provisions can trigger. You will lose the right of compounding also. So law has been strengthened in such a way that people will be forced to have, compliances under labor code. So OT related provisions was always there under the Shops and Establishment Act, but no one used to comply. Because what was the provision? 100 rupees or 50 rupees or 500 rupees. Now, like I was reading the provision for underpayment of wages. So first time non-compliance 50,000 rupees, second time non-compliance imprisonment of 1 year. So government may not invoke that so regularly, but then this kind of situation, that is where the employees will happen. So if they are doing a layoff, they have to plan it in such a way. Layoff can happen, right? It's a business cycle. Company can do that's right. But they should plan it in such a way that they should be paying the wages within 2 working days.
Which is what you mentioned earlier, right? You anyway have the 3-month period. So why don't you start doing the math earlier?
Yeah. So layoff, you must be planning for 6 months for layoff, right? For sudden release of people. So that time has to be used for that purpose also.
I think we can take one more question. I think there was a Mr. Abraham who had his.
Yeah, so my question is that if we get the documentation done for the new labor code digitally on the workflow, that's good enough, right? You don't need physical letters and documents being signed off.
So, Mr. Ibrahim, right?
That's right.
Yeah. So right now, the form and manner is yet to be prescribed by government. See, today also digitally, it is very well accepted. So companies have, kind of not doing manual registers and all. Even today, the Excel registers or digital registers are well accepted by the Labor Department. And that is expected to get modernized in due course of time, because it is expected that even the filings will be electronic, the registers will be electronic. That is what is the anticipation. We have to see how it is notified and how much government can bring support in terms of technology. But that should be a good compliance.
Okay, thank you.
Now, as an immediate next steps, right, what our organization needs to do. First and foremost, we discussed about payroll related aspects. So you need to understand your compensation structure, what is included, what is not included, because how you will calculate the wage, that understanding has to be clear. Your payroll process should be, your system should be able to calculate the wage, because earlier the calculation was on basic salary in most of the cases. Then there are some policies we discussed, loans and advances policies. If you have, that has to be updated because some restrictions are there on maximum deductions. The timelines have been prescribed, timelines for payment of wages by 7th for new joinees, then full and final settlement within 2 working days. So with regard to these changes, payroll system has to get updated. You need to initiate discussion with your payroll vendors. What we understand, when a client is approaching payroll vendor, the feedback what they are getting is that the system needs 3 months of time to get updated. So sooner the better you need to start this related discussion with your vendor stakeholders as soon as possible. The second one is in relation to the HR function. The leave related provisions are very critical. Then separation related benefits. Overtime, I told you, overtime kind of now is part of 2 codes, code on wages and OSHWC code. So overtime related aspects have to be introduced in the organization. And immediately the organization should start a worker versus employee analysis. That is very critical. We saw, right, so much of dependency on the number of workers in the organization. Third one, people who are in the finance domain, you have to close your books for 25-26. Lot of new concepts have come. Leave encashment related provisioning, gratuity, you need to have a dependency on wages. There is a 50% rule. So a combined reading, a team effort has to happen there, where all the teams are talking to each other. The finance team is taking inputs of the auditing team, the accounting team, and the HR team, so that you can correctly close your financials for FY 25-26. Maybe next year, 26-27, by that time, things will be settled. But today, a lot of ambiguities could be there in the organization, which needs to be cleared for the purpose of closure of books. Then we saw some of the new concepts coming. If you are into this platform work business or aggregator kind of model, then you need to have these policies, framework. You need to have a contribution. There's a 1% cess, which is introduced for these workers. You have to have that. In occupational safety, health and working conditions code, there are a lot of additional obligations which have been provided, which in relation to additional safety and health conditions for employees and workers. So these are the areas you have to inbuilt in your policies. If it is not there, you have to include it. I discussed there is a safety committee you have to create. And last one, manpower composition review. Immediately, if you have a lot of people through contractors, you have a dependency of workforce through third-party contractors, that arrangement has to be reviewed. You need to, even if you continue with that model, you need to have an assurance whether that model is allowed or not allowed in the new law. And then we discussed about fixed-term employees. So if you have anyone falling under fixed-term employees, then what are the additional obligations? What kind of changes are required in the contract? You need to take care of that. And along with that, parallelly, all your systems and all has to get updated. The payroll systems for correct wage calculation, the retirement systems which calculate the retirals, the processing timelines. Some of these business processes needs to be revisited. And last but not the least, this is the last slide from my side. We are kind of dot on time. As Vijay and I were discussing, there are a lot of provisions which have not come so far. And that's why there is a partial implementation of laws. Complete implementation of laws have not happened. So what are pending? The central and state rules, final rules are pending. You would have seen I spoke status quo has to be maintained for ESI and PF. That is pending. All of us are waiting for the final rules to get notified, which should happen, at least in the month of April, central rules should come. IW related provisions we discussed. There is no reference of international worker in the social rules which government will introduce. Then I think there was a question from Abraham, right, in the format of registers, right? So the compliance timelines, formats and registers, this has to be notified. There is a composition of offense scheme is there, and web-based inspection scheme is there. So now it is expected that manual interface with officers will be less. Most of the inspections will happen web-based. You will have the data digitally on some systems. It may be Shram Suvidha portal or some other portal which will be notified by government. Then web-based inspections will happen. Very similar to what we are doing today in income tax, right? Most of the data is there on the portal. The systems are enabled in such a way that they do analysis and they will issue the notices or clearances. Then this worker reskilling fund we discussed for people who will be retrenched. This fund has to be introduced. It is not yet introduced. Social security fund has to be introduced for gig and platform workers. Their 1% cess has to be contributed by these platforms such as Zomato, Swiggy and all. That is not yet introduced by the government. Then there is something called as now labor inspector will be called as inspector cum facilitator, right? So if it is the same branding of old wine, then that may not help. So we need to see what mean, whether it is the same state government official who was a labor inspector who becomes inspector cum facilitator, or there is some overlapping additional layer of administration which is introduced in the entire process. Then this industrial tribunals may not be very relevant for GCCs, but what happened at Delhi High Court, this matter went Delhi High Court and all, and government was High Court told them that you have not introduced enabling provisions for some of these, but that was rectified by government. And minimum wages also we discussed, the floor wage has to come, the new notification under the labor codes for minimum wages have to come. Till the time it is not coming, you will continue with your existing processes. Yeah, so we are dot on time. Any questions if you have, I'm happy to take. That brings end to our session. I'm happy to take any further questions.
Last question from me, and then we can probably hand to Prashanth if he's there for his closing remarks. I think at various points of time in today's Prashanth, handing it to you in a minute.
Okay.
Yeah, so various time during the conversation today, we spoke about some of the consequences.
Right.
They were varying specific, related to specific areas. But now, just to close, at a high level, what do you think are the top 3 consequences of non-compliance?
So, see, labor codes, you call it, good development or bad development. There is the tolerance level to non-compliance, at least from the words which are there in the law, is very low. So that's why that graded mechanism is coming into picture. First time non-compliance is okay. By monetary fines, you can go out of it, compounding and all you can do. Second, non-compliance, repeat non-compliance is considered very, very seriously. So you would have seen government is, removing all these imprisonment related, decriminalizing the laws. But in labor codes, they have kept it deliberately. So earlier, when the labor violations, labor law violations was very blatant and very obvious because laws were not very stringent. But now, from the provisions of law itself, there are imprisonment related provisions. There are a lot of penal provisions in the law for repeat non-compliances. So companies have to have very in-depth analysis of the provisions which are applicable for them, how it is impacting. And a lot of feedback comes from every employee. What someone told me that every employee in our organization has become HR after labor codes. Everyone has a view on labor codes. So don't go with that opinion. Have a proper analysis, either in-house or through external parties. What are the provisions which are impacting you? If you are compliant, well and good. If you are non-compliant, you should know at least that you are not non-compliant, and some repercussions could come in due course of time. So be very careful with the new law. Government has, when they introduced this law on 21st of November 25, based on informal discussion with Labour Ministry, we understand the intent was to provide this window of 21st November to 31st March for implementation of laws. It was kind of informally suggested that the enforcement of laws will not be there. But from 1st of April, the enforcement of laws will also be there. Right. So we have to be very, very careful in terms of absorbing the changes, implementing those changes, and correctly implementing those changes so that you are on the right side of compliances.
Great. Thanks, Ankur.
Yeah.
Prashanth, over to you.
Thanks, Vijay. Thank you, Ankur. I would like to sincerely thank Ankur for your excellent and insightful presentation. I think, I'm sure all the participants, we had an overwhelming participation for this webinar. I'm sure they get benefited with this highly informative, and also you offered very clear, actionable insights. And I'm sure it will be appreciated by all of our participants. And I also take this opportunity to thank Vijay for moderating this session. Thank you, Vijay. I truly appreciate. And also extend my gratitude to team BCCI for organizing and enabling this important webinar. I think it provided, in summary, a much needed platform for many FAQs. I think many of the companies are grappling with how to effectively implement the new labor code while ensuring compliance. I think, Ankur, you did a fantastic job in clearing many of such apprehensions each one of us has. And if any of the companies in future want to engage in official capacity, I think you can contact Ankur directly. With that, thank you so much, and we can conclude the webinar.
Thank you.
Thank you.
Thank you. Thank you, sir.
Thank you.
Thank you.
Thank you. Thank you. Thanks, everyone. Thank you.
Thank you.